The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Welcome to this special session of the Iowa Supreme Court held at West High School in Iowa City. We appreciate you spending a part of your evening with us, and we hope you find it be enjoyable. We have two cases that will be presented this evening. They are State of Iowa versus Zachariah Rogerson, and the second case, the State of Iowa versus Lewison. We'll now hear the arguments in the first case. Mr. Spannagel, you may proceed.
May it please the court, opposing counsel. My name is Brian Spannagel, and I represent Zachariah Rogerson, the appellant in this case. Mr. Rogerson was charged with operating while intoxicated, causing serious bodily injury, and the state filed a motion for distance testimony to allow witnesses, not just one witness, but several witnesses, to testify via the Iowa Communications Network, which is essentially television, similar to Skype. And what happened was the district court granted that motion. We believe that district court here granted the motion. It's our position that Mr. Rogerson's confrontation clause rights were violated under the 6th Amendment of the U.S. Constitution and also Article 1, Section 10 of the Iowa Constitution. Both constitutions require a finding of necessity before witnesses can testify outside of the presence of the witness. There's been a very narrow exception to this, and that would be the child abuse cases. I think we're all familiar with Coy v. Iowa, and in that case, there was a child who was testified behind a screen so that she did not have to see the perpetrator or the alleged.
Counsel, can our evolving technology change the meaning of confrontation under our Constitution?
I do not believe that it can change the requirement for a physical face-to-face confrontation unless there is a finding of necessity to outweigh the defendant's right to a physical face-to-face confrontation.
That has been our test, but is the way that we communicate, which is so much different today than it was just a short time ago, does that cry out for a new test to be developed?
No, it does not, Your Honor. For centuries, since day one of this country, people or defendants have had a right to a physical face-to-face confrontation. And although technology has changed, there is nothing different about the way that people testify.
What's so special about a face-to-face confrontation versus a television that's interactive, where people can see the person testifying and see the person asking the question?
The truth-inducing effect. There is something about face-to-face confrontation that is different than a screen or camera confrontation. And the precedents from the U.S. Supreme Court, the 11th Circuit, the 8th Circuit, all of these precedents say that there is something about the nuances of being in a courtroom with the accuser.
Counsel, did any of those cases involve real-time two-way technology?
technology.
Yes, Your Honor. The U.S. v. Bordeaux case did, and that's an 8th Circuit case, which Iowa is in the 8th Circuit. It's a persuasive case that involved two-way closed-circuit testimony similar to the ICF. And in that case, the 8th Circuit said, no, it's not the same. Two-way communication via TV is not the same as an in-person, physical, face-to-face confrontation.
Well,
it's
not
not
the
the
same.
same.
I think we're at the same place. It's not the same, but it doesn't make a constitutional difference. You have full opportunity to cross-examine. The defense counsel can ask full panel questions, and the fact finder has full opportunity to view the witness responding to the cross-examination. Isn't that the core of confrontation?
Well, it allows for a virtual confrontation, and the 8th Circuit rejected that to be constitutional equivalent. Now, I think we have to look at the reliability of the virtual confrontation.
Well, why is it unreliable?
It's unreliable because we don't know what's going on behind the screen. There's something, we don't know if there's off-screen coaching. We don't know if a witness is wearing an earpiece and somebody is talking.
But you can take care of all that by asking those questions before, and I'm sure the judge would probably ask those questions. If I was trying to present someone that way, I would ask those questions so the jury or the finder of fact knows those things aren't present. And if there is someone here, that's a different question. But none of those problems are here. I mean, what are you missing by watching somebody on TV? I mean, you say it's different, but they're still on their oath, they're still subject to perjury. I don't think perjury to lie. All the things are there, so what are you missing? And high definition TV, you can see people sweating. So tell me what you're missing.
You're missing, well, Your Honor, quite frankly, there was no evidence put on by the state about how the ICN technology could show somebody sweating.
What evidence is there in the record? I mean, I understand there was a motion filed, and there was a response to the motion, and then there was some oral argument. Any evidence taken at all about technology or circumstances which this two-way video was going to operate?
There was absolutely no evidence put on. There was only assertions by the state. The assertions were that there was the ICN network. It was a two-way technology that the witnesses may not be able to testify, that there was no medical finding that the witnesses were unable to travel or it was medically unsafe for them to travel. There was no evidence showing that they were outside the reach of the subpoena power. There was no evidence.
All right, well, let's deal with the changing times. Some of the older cases talk about looking you in the eye, and they talk about President Eisenhower's view of Appellee, and look someone right square in the face and could evaluate credibility. But that was 40 years ago. Now everyone is using technology. So the old notion was look me in the eye, and that was thought to be significant. But today, does that have as much friction? So with all our cell phones and tablets and videos.
Although technology has changed, people are still hardwired the same. There's nothing different about wanting to confront somebody to their face when someone is accusing you of something. Don't you want to be able to see them in the same room and have the opportunity to have them testify in a setting where they're not insulated from technology?
Well, was that the purpose of the confrontation clause? To look somebody in the eye, or wasn't really the purpose of the confrontation clause to give you a meaningful opportunity to test the credibility and statements of a witness through cross-examination. You're saying that the Confrontation Clause means more than that, where in order to do that, they have to be in the courtroom. But where does that come from in our Constitution?
Well, the purpose of the Confrontation Clause is rigorous testing in the context of the adversarial setting. When you remove someone on a per se rule and say we're going to just not require people to come to court unless, even if there's no finding, if you remove someone from the adversarial setting of the courtroom, insulate them on a television screen, you lose something about the cross-examination.
But isn't the history of the Confrontation Clause was to prevent magistrates in the old days, before we had our Constitution, from coming into court, reading what everybody said, and all the witness statements, and they convicted people. And if you read some of Justice Scalia's opinions on the Confrontation Clause, that was the purpose of it, to prevent that from happening. And now you're taking this leap, or you're asking us to take this leap, that now means you have to look someone eye to eye, rather than cross-examine. So, I mean, where did that leap come, and where is that supported?
Well, many years ago, there was people used to be convicted by affidavit. And I think that's what you're getting at. And what the affidavit was unreliable, because people were making statements. They could have been coached to make those statements. And there is a similarity between allowing someone to testify outside of the courtroom that we don't know what's going on. They could be 500 miles away, 1,000 miles away, and their testimony could be the same as an affidavit. They could be being coached on what to say, and no matter what kinds of questions you ask them, they will give you the responses that they're looking for.
Does your argument depend on the witness being available or unavailable? I mean, is it the same if they're unavailable when you say the state can't produce them after dismissing a case? I mean, do you make that distinction?
There's different kinds of unavailability under the rules of evidence. And what the U.S. Supreme Court and the other courts that looked at this have found is a witness who's unavailable, a child witness who's essentially unavailable because they can't get their testimony out in front of the accuser. They can testify by telephone. A person who is not subject to the subpoena powers and they're unwilling to come to trial, well, there's a necessity there. The defendant's confrontation right is outweighed by the necessity of getting crucial evidence in court. There's the medically unsafe cases where somebody cannot physically get to court because they have terminal cancer and a doctor has said, no, it's medically unsafe for them to travel. That kind of unavailability is where I think the standard should be, not any other type of unavailability where you just can't find the witness, therefore, you find them at the last minute, they can testify by a second.
How important were these witnesses to the case?
They were crucial to the case, according to the case law. They were important witnesses. And in our case, the witnesses, they would be necessary for the state to prove their case in chief. And also, we're at the stage in this case where we don't even know whether the witness's testimony would be. This is an interlocutory appeal. There's been no conviction.
But of course, you could avail yourself of discovery if you chose to do that in the criminal process. You could find out what the testimony is. Or you could even hire a private investigator. I mean, you're not really barred from finding that out, are you?
At this point, we've not had an opportunity for a face-to-face confrontation. And I would point out that in the cases where, at least under the federal rules, in the cases where the witnesses cannot travel, the Congress, the court, the Supreme Court has thought that this right is so important that under Rule 15, the defendant actually has a right to go and depose the witness where they're located with the defense counsel. There's all kinds of, I guess, impracticalities too by video testimony. In theory, it sounds great, but actually, there's delays in transmission. I think the ICM can push a button in order to talk.
Of course, the record doesn't show that. I mean, the record shows next to nothing, frankly, from what I can tell. I mean, it was, correct me if I'm wrong, of course, but it was just oral argument. We have no idea what the quality of ICM is or isn't. I take it that's a question of fact. We have no idea how far the witnesses were. I take it that's a question of fact. We don't know. So where does that leave us?
Well, I think that leaves us with that the state is not showing that there's any reason that outweighs the standard under credit, which is a physical face-to-face confrontation, unless there's a showing of necessity.
A cynic might say you're just trying to make the prosecution expensive. Travel distances and so forth. You're trying to make it inconvenient. You're trying to put up burdens for the state to get what is essentially undisputed testimony. How would you respond to that?
As the case law says, there's always a cost for upholding constitutional rights, and the cost is subordinate to anything else when it comes to the constitutional right. What we have here is people's lives, let's say. Not just my mind, but if you were to rule to allow video testimony, whatever, we're going to be putting people in jail. We're going to be taking people's property when we haven't had a chance to confront them in any way except via the mail. And so, although there's a cost, there's also a cost to the court system. Every time that we have to subpoena people, there's a cost of holding people in contempt. There's a cost to your First Amendment rights. There's a cost to every single one of your rights, especially in the Bill of Rights. And that's part of what this society is about. We put people's lives above cause. And so for those reasons, especially if there was no finding of necessity in this case, or even a proper record, Your Honors, we ask that you reverse the district court's order and set this case for, or remand this case for further proceedings.
Thank you, Mr. Spannagel. Mr. Cmelik. Mr. Cmelik, could you draw the microphone close so we make sure that we hear you? Thank you.
May it please the court. My name is Cmelik. I'm with the Attorney General's Office, and I represent the state of Iowa in this case. There is no doubt that one of the necessary questions to resolve in this case is what is the application of Maryland v. Gray to the factual and legal posture we have before the court today. It's the state's position that it has no application, that its facts are significantly different and its legal posture is so different that we're in new kind of uncharted territory.
Before we get there, though, whose burden is it to show that there's proper confrontation? Would it be the state's, or would it be the burden of the defendant to show there isn't proper confrontation?
In this circumstance, of course, in an abundance of caution, the state filed this motion to say allow us to confront or to offer this evidence through video testimony. But my position would be the state didn't have to do that. If they were going to come in and offer these witnesses and satisfy the confrontation clause, you don't need a pretrial hearing to resolve that. And if you want to contest that it isn't sufficient under the confrontation clause, lodge your objections and point to the specific facts that make it not satisfy that clause.
But it's a constitutional right, and that usually requires a waiver by the defendant of a constitutional right. So shouldn't the proper burden be on the state to show that there are no confrontation clause problems?
Well, I'm saying there's no waiver necessary here because the method that's followed satisfies the Constitution and the confrontation clause. So if there's an objection to be lodged to it,
Okay, let's take a case where we don't know if it is. And, you know, the problem when you do a burden is that whoever's burden is, if it's an equal vote, they lose. You know, you can't tell one way or the other. So there has to be some kind of burden. And not just this case, because we're talking about hundreds and thousands of cases, maybe. So where would the burden be to show that the defendant's right to confrontation is not effective in any way? Don't you think it has to do with the state?
I think the state has the obligation to come forward with the evidence in the way they choose to present it. If they believe the way they're presenting it is constitutional, then some objection must be lodged, and some specific objection must be made as to why it violates the Constitution.
Yeah, that just seems backwards to me. It seems to me that the burden clearly has to be on the state. Anytime you have a criminal trial of this nature, the normalcy is always going to be that the state's going to present live testimony from the witnesses in order to prove their case. You're now saying, well, we're not going to do that anymore. We want permission to do it this other way. And again, based upon this record, there's really nothing there other than we want to do it and we think it meets that confrontation requirement.
I would agree with the court in the sense that it seems backwards because it's not the method that we would normally follow in a criminal case. We're used to someone saying, go out in the hall and bring in the next witness. And nobody questions, okay, is that satisfying confrontation? If they somehow protect that witness in the courtroom, someone might object and say that violates confrontation. But the assumption is when we call the witness to the stand in a way that satisfies the confrontation clause, we do that by calling them to the stand. And I'm submitting to you we're doing that. We're calling them to the stand through video conferencing. Well, now, you could object to that, sir.
I have a question, Mr. Stone. And it goes to this point about the importance of the in-person presence in the courtroom as a piece of the confrontation right. You know, we do a lot of things in the courtroom, as you know, to get at the truth. We administer oaths to witnesses, the function of cross-examination, the great engine of getting at the truth. And I'm of the view personally that this ability to require your accuser to do it face-to-face is an important right, an important aspect of the confrontation right. But I guess I'd like you to comment about your own view about whether the confrontation face-to-face through a two-way video is just as good in that particular way as the live in the courtroom confrontation.
My view is that while it may not be exactly the same as face-to-face confrontation with physical presence, it is so insignificantly different as to not violate the Constitution. And why I say that is if you look at the cases that have discussed this.
Well, how is it different? I mean, other than the fact that the witnesses are there and the confrontations occurring on the screen. I mean, isn't that a function of forcing the accuser to do it face-to-face still there in the sense that both faces, both visages are viewable, both by the accuser and the witness?
That's absolutely right.
And by the jury or the judge that's watching?
The only distinction that I would draw for you is that maybe you don't see the entire body, the entire demeanor that witness would bring to the stand. But I would submit to you that
Isn't that critical? I mean, when you have conflicting testimony and a fact finder is trying to determine credibility, isn't there a substantial difference between having someone directly in the courtroom and with the jury or fact finder can view straight on compared to somebody 50,000 miles away, probably, but a long way, on a TV screen with a flat ass?
I actually, my response to that would be, Your Honor, I think not. Because can you see my whole body from where you're sitting right now? And that's the way every courtroom in the nation is set up. There's a witness box. It disguises the witness in everything but the waist up. You can have that same exposure to the jury with the television.
Oh, but it's a much different experience hearing. So a witness comes in the courtroom. You've got the flags, you've got the judge seated, you've got the jury, and you've got the prepared defense counsel. And the drama of the courtroom, frankly, very basic stuff, but it's actually true. Lawyers work on trying to control the issue. Lawyers work on trying to control the courtroom. It fashion the cross-examination based on observation of the witness. It's a matter of timing and rhythm and strategy made by a skilled trial lawyer based on what's physically happening in the courtroom. But on the TV screen, isn't there a difference?
I think my response to you would go back to Justice Katie's point, and that is, it might be to us, those of us that grew up watching television, but it isn't to the kids that are growing up today, the ones that Skype with their father in Japan, and understand if they don't go to bed when he says to, they're going to get the same consequences as if he'd been.
Yeah, but this isn't Skyping from Japan. I mean, when I go to my neighbor's house, the doctor, he has his 80-inch screen TV and 14 speakers, and you can see the sweat rolling down people's face. But you deal with the ICM, which is 20-year-old technology. It surely isn't high definition. Only one person can talk at a time. So if the witness is talking and someone makes an objection, the witness can't hear it and stop talking. The judge can't stop him from answering the question. Can we take judicial notice of the fact that the technology that you want to use just ain't there?
Well, I don't know that it's fair to take judicial notice of facts that aren't in the record. We all have to live with the ICM, we've all used it. But still, I think that record should be made. And that kind of goes to the question here. If the court finds, I mean, that's a question for saying in a particular instance, it would not satisfy
But
confiscation.
you make that record that this is the same, this ICM that you want to use, which is 20 years old, which has all these problems that we know about through our use of it, through your use of it. All right, did you make the record to show that that technology is the same technology or as close as you can to being in the room in person?
I can see that record was not made below, but that's not necessarily a ground for saying that this is unconstitutional. It might be a ground for remand to further develop a factual record, but it isn't critical to the decision of, is the notion of two-way video unconstitutional?
Mr. Simon, let me pose this. Is what you're asking for in this case, is this something that the state, in the big picture, so to speak, really wants? Because imagine what criminal trials would become if defendants could bring their witnesses in by TV, prosecution by TV. If I'm a juror, I'm going to think, well, maybe I can participate by TV from home. That wouldn't be kind of an unsatisfactory, unsatisfying way to administer justice.
Well, I have two responses to that. One is my response in terms of my old ways. I'm more comfortable with the traditional notion of trial. But again, I submit there are a lot of people who aren't more comfortable with the traditional notion of trial. And the question is whether we're satisfying the core principles of confrontation by having a virtual trial, to use that phrase. And there are certainly a large segment of the population today that would accept that's fulfilling the exact same purpose. And I want to get to that idea of physical presence. I think that's important in this case.
But first, could you address the concern expressed in a number of the cases that it's easier to lie if you're at a remote location, and it's harder to lie if you're in the same room with all the or
I hesitate to be trite, but I think, first of all, that's not true. I mean, I've been in trials. I've seen people lie to my face. I know that happens. It's easy. Is it more difficult to do that or easier to do that if I'm in a different location? I don't know if the threat of perjury is still there. I mean, with that threat still there, I think it does cause people pause. If there is this two-way communication going on, so there's actually an interaction and there's some pressure being applied by counsel, I think you get the same kind of result. So I'm not sure that physical presence really guarantees that. And I would point out that the courts, when they talk about it in old Supreme Court cases, talk about the symbolic importance of physical presence. And the other thing that I would point out about physical presence...
Can you text your testimony? You get your on your iPhone, and I'll get on my iPhone or whatever we have, and I'll text the question, and you'll text it back to me, because that's what my kids use now.
I think that's right, but unfortunately you're not satisfying the last kind of core principle of confrontation, and that is the ability to see the demeanor of witness. And I think that's important to the analysis. But again, this physical presence, I want to point out that when we talk about the old cases, Kirby, we talk about California versus Green, and we talk about Douglas versus The court said in those cases physical presence is at the core of the confrontation clause because that's the only way you could get it. Yeah.
Well, what about 2002 when the Federal Advisory Committee on Criminal Procedure made this proposal, which is basically, as I read it, consistent with your position, and the Supreme Court rejected it with an opinion by Justice Scalia, which basically said, that virtual testimony is inadequate for the confrontation clause. Now, that was Scalia's opinion, and simply a response to the proposal. But as of 2002, the Supreme Court was unwilling to bless what you proposed.
12 years is a long time in technology today. That would be my first response. And that was 12 years ago.
What about the Bordeaux case did in 2005? 2005, we're getting closer now, and they say exactly the same thing. That two-way communication is still not sufficient. And I guess kind of following up on that, do you concede at all that there is any benefit at all to having personal presence of a witness at the trial?
Again, I would admit to the court, for me, there seems to be a personal benefit because I'm stuck in the old ways. I'm not so sure that that's true as technology moves forward.
But people like you are going to be on the jury.
True. And maybe we have to bring people into the modern age, and we won't do that until we start this practice. Bordeaux, just to answer that particular question, I think there is this natural tendency in courts to be conservative. They take and apply Craig, because that's all they have to apply at that particular age. But if you look at the rationale in Bordeaux, what is it that they offer that actually says it's different? I mean, they say that there are fine nuances you might pick up. They don't explain what those nuances are. They don't talk about if you can see the sweat on your brow. They don't talk about when you can hear the quake in your voice.
What's in the sociology studies show? Does anybody check that to see what the sociology says?
There are
psychiatrists say about being present and not being present.
No, I can't say that research was done for this particular purpose. There certainly are law review articles that we've cited that talk about the advantages and disadvantages.
Well, wait a minute. The Supreme Court talked about President Eisenhower and the Appellant Code in kind of colorful language. Yes. We can all understand that here in the West. The notion is you don't lie to my face. But and that's what the Supreme Court has said. And of course, for First Amendment or Sixth Amendment purposes, we need to follow what the United States Supreme Court says.
I would submit to you that's what Justice Scalia said. If you look at Floyd, it's a 4-2-2 decision. And the concurrences in that case by Justice O'Connor and Justice White don't accept that proposition. And so the kind of core issue is, under the circumstances in the Floyd case, did we have confrontation? And I think that's the narrowest opinion that you could draw.
Don't people still today make their most important decisions face to face? You buy a car on the internet, the majority of people don't. You buy a house on the internet, people don't. You want to have a face-to-face with the person you're dealing with, so you get some kind of comfort level that the person you're dealing with is honest and fair and giving you a clear deal. And this is just changing that whole equation.
I don't know that that's true. I bought 2 motorcycles off the internet. I search houses on the internet. So I don't know that I can accept that proposition, other than to say there are certain segments of society that is more comfortable with that.
If we do what you ask, would we be the first court in the country, or first state Supreme Court, to hold that two-way video satisfies a confrontation clause in a criminal trial?
Well, it depends how far you go in your decision. Certainly other courts, like in Gigante and in Root in New York, have said we don't think Craig applies, and we think this is a different factual circumstance.
Well, Gigante involved threats by mobsters of the witnesses themselves.
And that's what the 11th Circuit said in response to that decision, saying they really were looking at something beyond Craig. But even if you apply Craig, if I can continue my answer, even if you apply Craig, those courts are applying something other than Craig when they propose the test they propose.
Right.
Because it's not the necessity that's in Craig that they're finding.
And they had what they thought were more compelling circumstances than Craig. And Craig, of course, was a 5-4 opinion with 4 following Scalia, basically saying a confrontation clause is absolute. So just counting to 5, we've got 4 following Scalia saying it's absolute.
And I guess my response to that in summation would be, if we can take anything from Justice Sotomayor's, dissent from the grant of the writ for certiorari. She certainly viewed Craig as not being applicable and thinks the Supreme Court should take that issue up again someday. And that's what I propose to this court. Thank you.
Thank you as well, Counsel. Final argument?
A couple of brief points here. The first is I wanted to point out, and I think it's obvious, that Rule 26, that proposed rule that the U.S. Supreme Court said was of dubious validity and did not pass, that was in 2002. The ICN technology has not changed since then in our same technology. The other thing is I believe that Coy v. Iowa was actually a 5-4 decision. It was not a plurality. That was by Justice Scalia. And then there was some very interesting things I think said about searching for a house. When you search for a house, now you can look at it online, but there's still real estate agents out there, and home sellers have to clean their house and get it ready for people to look through. And I mean, we do a lot of real estate, and I've never had a home buyer not look at the house if they're going to be residing in it without physically going through it, because there's something different about looking at it in person and seeing it. The other, I think, important thing as we look at this is there's going to be a lot of practical problems if we all of a sudden just say we're going to open up the floodgates and allow for video technology for Skype to be in the courtrooms. First, what is the contempt power we're going to have on some witness over in Alaska? I guess we could issue a nationwide warrant for his arrest, but then give the extradition power. That's just one of the many problems. There's all kinds of problems with technology, all kinds of questions that need to be answered. How big does the screen have to be? What kind of technology do we need? How many cameras are going to be in the courtroom? How do we know the witness is seeing the defendant is seeing the witness? There's a whole can of worms. And then what's the next step? Are jurors just going to be able to just log in and watch the trial, and will the judge stay at home? What's the significance of the court system at that point? The courtroom is an important place to be. It impresses upon us the seriousness of the actions. Whether the defendant is confronting the witness is confronting the defendant, there's an importance about that. Now, you also asked, is there any way or any other court that's ruled that there's just a per se rule for video technology? We now have televisions and therefore we should allow it in the courtroom all the time whenever the state asks for it. No, there's not. Not a single case. And there's not even a single case in the state's brief that even comes close to supporting that. The Gagano case has nothing to do with saying we do not need to make video technology used all the time. What it says is, well, we don't agree with the Craig standard, but there still needs to be exceptional circumstances and unavailability. It needs to be narrowly circumscribed and can't be the norm. All of the other cases involve showings of necessity. You have Abu Ali, it's a terrorist case with somebody outside of the subpoena powers of the United States, and the Saudi government won't allow a person to testify. You've got Horn v. Quarterman, where there's somebody charged with murder in Texas, and a very important witness is in Ohio, terminally ill with cancer. Those are important reasons to maybe use this technology, but there's a showing. Those are the cases that are very, very different in our case. In our case, there's no showing of any kind of necessity, whether you apply Craig's standard or some other proposed standard. The scholarly literature by the state does not support a per se rule. That literature even says that it needs to be carefully circumscribed. I think the most compelling article I read on it that the state suggested, or that the state cited, was the Michigan law article by Friedman. And he even says that Rule 26 needed to be narrowly tailored. And this was somebody who was advocating for use of technology, but Rule 26, that proposed rule, he agreed it was too long. And so we have Supreme Court justices saying that we should not allow it. We have circuit court saying we shouldn't allow it. We have scholarly articles saying we should not allow it. Very school professors saying we need to be very careful with this.
What do you make of Justice Sotomayor's comment that maybe Craig doesn't apply in this situation?
Well, I think it's open for interpretation, but just because Craig doesn't apply doesn't mean some other standard doesn't.
Well, it could mean she was consent. Craig.
It could. Yes. So, Justices, once again, I ask that you reverse this district court order and set it for further proceedings. Thank you.
Thank you as well, Counsel. The case of State versus Rogerson is submitted, and we'll now hear the arguments in State versus Lewisell.